Good afternoon, everyone. On behalf of myself and the Touro Law Review, I just wanted to thank Mr. Cahn for joining us today, and I want to also thank Professor Klein and Professor Citron for being here. And without any further ado, I'll turn it over to Professor Klein.
This is one of those cases, and there aren't that many in this country, that are highly publicized matters and just keep on going on. And the Jeffrey MacDonald case goes back to a homicide, to a murder that had occurred in 1970. And it's gone on with various amount of publicity, been covered all of these years, and just in September of this year, the case was back before the federal district court, and the judge now in that case is going to make a decision whether or not there's sufficient new evidence to call for a new trial. But I think Richard Cahn is someone who has written about this matter, was the representative, the lawyer for the parents of the woman who was allegedly killed by Jeffrey MacDonald. And let me just say a word about Richard. He's a Yale law graduate, had worked for years in the U.S. Department of Justice. Then he became a criminal defense lawyer, got 18B assignments, which most students here are aware of. He's done a lot of federal civil litigation. He's been appointed once a special prosecutor in Suffolk County on a murder case. He's been the president of the Suffolk County Bar Association, and I think it's really great to have Richard Cahn here with us today.
Well, thank you very much. This is indeed an interesting case, and a case that never dies. I would take exception to one of Professor Klein's comments in which he said that Jeffrey MacDonald allegedly killed his wife and daughters. He has been convicted of those crimes, and I don't think that there is any longer any allegedly about it. To be sure, there have been legal proceedings for almost 40 years since his conviction, in which he has tried one legal theory after another to try and set aside his conviction, but the convictions, triple convictions, still stand. So the case did attract a great deal of media attention in 1970 and thereafter. In 1970, you had a murder in officers' quarters at Fort Bragg, North Carolina, a military reservation. The victims were the wife and two infant daughters of an Army captain who, by the way, was a physician and a Green Beret. And you will recall, I'm sure, from reading history, you're all too young to have lived through it, but the Green Berets were a subject of a lot of talk at the time of the Vietnam War, and there were quite a lot of strong feelings about them. So for all of those, because of all of those factors, this case attracted a lot of attention. It also, like so many sensational cases, attracted attention because of the lurid and sensational nature of the crimes. Two little girls, 5 and 2 years of age, brutally bludgeoned and stabbed to death. A wife, pregnant, 6 months, with a baby boy, also bludgeoned and stabbed repeatedly until she died. The fact that there was a continuing mystery for some time about the identity of the murderer was also something that provoked a lot of media coverage. Let me start first with the crimes themselves. This all happened on the night and the early morning hours of February 17th, 1970, at 544 Castle Drive at Fort Bragg, North Carolina. It's a small house. It's officers' quarters occupied by a Green Beret Army doctor and Captain Jeffrey MacDonald, his wife Colette, who was 26 years of age, their two daughters, Kimberly, 5, and Kristen, 2. And as I indicated, Colette was pregnant with a third child, a boy. When the MPs responded to MacDonald's telephone call for help shortly before 4 a.m. on February 17th, they found 3 dead bodies. Colette was sprawled on the floor of the master bedroom. On the headboard of the bed was written the bloody word pig. Kimberly and Kristen were dead, each tucked under the covers in her own bed. When the covers were pulled back, it was gruesomely clear that both girls, like their mother, had been bludgeoned and stabbed, and the Army CID, the Criminal Investigations Division, was immediately summoned. Now, MacDonald was alive, the only male on premises, the only person who presumably would have been in the best position to defend himself. He was given some 8 or possibly 10 superficial stab wounds in and about his chest and abdomen. The number of stab wounds, which he, by the way, later on began to say were actually 22 stab wounds, and several of them were life-threatening. But there were 8 or 10 stab wounds, quite superficial, and the question immediately arose in the minds of the investigators: why was the man left alive and this brutal series of killings taking place all around him? It just didn't compute. MacDonald told his story. He claimed that he had fallen asleep on the couch in the living room. His wife was in the master bedroom. The 2 little girls were in their beds. He was awakened by 4 bizarre-looking intruders, a woman with a floppy hat chanting, "Acid is groovy, kill the pigs," a large, muscular black man, and 2 other hippie types who were white. From the master bedroom, he heard his wife's voice, Jeff, why are they doing this to me?" MacDonald tried to rise from the couch, but his arms were tangled in his pajama top. He was unable to defend himself, and he was struck repeatedly on the head by the black man, swinging a club or bludgeon like a baseball bat over his head. He was specific about that. He then felt sharp pain in his chest or abdomen, and he lost consciousness. When he woke sometime later, the apartment was silent, and he went and investigated and found his wife's body on the floor of the master bedroom. He took off his pajama top and he placed it over her chest, tried to give her mouth-to-mouth resuscitation, unsuccessfully, went to see what had happened to the girls. They were in their beds, and they were dead as well. He then called the military police. Now, he was on active duty with the Army at the time, and there was an investigation. And some weeks after, MacDonald was told by the criminal investigating authorities that he was under investigation for these murders, and that an Article 32 proceeding would be convened to determine whether there was probable cause to hold a general court-martial. That's a procedure under the Code of Military Justice. It's the equivalent of the civilian grand jury. An investigating officer hears evidence, including from the accused if he wishes. He doesn't have to testify. And he makes a determination whether there's probable cause. The hearing went on for 25 days. MacDonald insisted upon testifying, and he gave very, very specific details about what he did and what he did not do. And he was innocent. It was these 4 intruders. Well, at the end of the Article 32 proceeding, Colonel Warren Rock, who was the investigating officer, issued his report, finding not only that there was no probable cause to hold MacDonald, but that MacDonald was in fact innocent, something that goes way beyond an investigating officer's charge in that kind of a military justice proceeding. The Army was, the Army CID, the investigators, were outraged. They felt from the beginning that the man was guilty, and there were just too many unexplained circumstances. It was a rainy night. There was no sign of intruders in the apartment, no forced entry, no mud on the floor, no rain streaks. The neighbors, the Kalins, had a dog which always barked at intruders or any disturbance in the neighborhood. Truly, like the Sherlock Holmes story, this was a story where the dog didn't bark. There were rubber surgical gloves inside a kitchen cabinet that Captain MacDonald, who was a surgeon, used. And one of those gloves was found torn and bloody on the floor of the master bedroom. There was no sign of a struggle. He had testified at the Article 32 proceeding that these four intruders, three of them men attacking him while the woman chanted, and yet there was no sign of a struggle. The taller of the three men, the black man, repeatedly, he said he held the bludgeon over his head and came down vertically and struck him on the head and the shoulder. And yet you have a 7-foot ceiling in that room, and it is absolutely impossible to have that kind of activity take place without there being some marks in the ceiling, something on the floor. He claimed his pajama top was torn there in the living room. No fibers from the pajama top were found on the living room floor.
Let me just ask a question for a minute. In spite of everything that you've been saying, he was found at that hearing not to have been responsible for the deaths, and the next step would have been to get the U.S. Attorney's Office to have indicted him. And I think there were attempts to get the U.S. Attorney's Office to have a grand jury sit and then to proceed, hopefully, to indict Jeffrey MacDonald for the murders, but that didn't occur initially. If you just want to talk about
that's right. Well, it couldn't have occurred while he was in the service, because then he would have been subject to a general court-martial. He was released. There was a reinvestigation by the Army CID. He was, by that time, in California practicing medicine again, trying to make a new life for himself. And his in-laws, who had first very publicly come to his defense, began to doubt what had happened. They finally got their hands on the Article 32 transcript, and they realized that all of the information that Jeffrey had told them during these nightly phone calls after every session of the Article 32 hearing, all of that was inconsistent with the physical evidence or plain lies. And so they were encouraging the CID. The CID came out with a report a year and a half later saying that they thought there was a prima facie case against this man, and the case ought now to be presented to the grand jury because now he was a civilian. And the Justice Department refused to act. To make a very long story short, the Kastabs, the parents of Colette, became increasingly frustrated. They were clients of a lawyer here in Suffolk County who had represented them in a house closing, but I did a lot of federal work. He didn't, and he realized this was something that had federal implications, so he referred them to me. And I, having been in the Department of Justice and having, by the way, worked for L. Patrick Gray, who in 1972-73 was the acting head of the FBI in the Nixon administration, I thought that perhaps I could prevail upon some of the people I knew at Justice, or maybe Pat Gray himself, to do something to get this case started again. We struck out, got no response. I didn't even get a personal letter from my old friend Pat Gray. Turned out much later I found out why I didn't hear from him. Watergate had just happened, and he had just plunged into that and realized that the Watergate scandal actually extended into the White House, and he had his hands, he had a full plate. He was not able to really give personal attention to everything else, and I learned that some years later. So anyway, in answer to Professor Klein's question, the thing that I think that I was proudest of, if you'll allow me to say that, is that I just remembered from law school that one of my professors, probably in a criminal law course, said, look at the procedure. Procedure is not only important, the procedure is everything. So I looked at the way the federal government starts a criminal prosecution. Well, a criminal prosecution starts with the filing of a complaint. So I looked at Rule 3 of the Rules of Criminal Procedure, and I found to my surprise that a criminal complaint does not have to be signed by an investigating officer. It does not have to be signed by law enforcement or by FBI or the Secret Service or the Treasury. It can be presented by anyone having notice of the facts or knowledge of the facts. And once a Rule 3 complaint is presented to a federal magistrate judge, then the judge has a duty to read it, and if he believes under Rule 4 that an offense has been committed and that the defendant committed it, if there's probable cause in his opinion, he must issue an arrest warrant to an officer authorized to execute it, and he may alternatively convene a grand jury. I didn't know about those things. I'd never had occasion to do that. So the Casabs came to my office in Huntington, and we spent a lot of time together reconstructing what happened, looking over the Article 32 proceedings. Pete Kearns, a captain in the Army CID who conducted the reinvestigation and who concluded that there was probable cause to prosecute MacDonald, he came to my office, and he has such a detailed knowledge of the case that I sat him down in a room with my secretary, who took shorthand, and for an hour he dictated his recollection of the case and his reactions and so forth, so that from that material, after she typed it up, I could draw up a criminal complaint. And that's what we did. We took it down to North Carolina, to the basement of a federal courthouse building in Clinton, North Carolina, basement of a post office building, where Judge Algernon Butler, the chief judge in the Eastern District of North Carolina, had his chambers. I had called him 8 days before, told him that I wanted to appear with the Casabs and what it was about. He was surprisingly friendly and hospitable and obviously interested in the case. And we appeared. Tom McNamara, the U.S. attorney, who also comes from Long Island, by the way, was there. It turns out, and McNamara, of course, was the guy who 2 years before, upon becoming U.S. Attorney, had written a prosecutorial memorandum to the Justice Department urging the Justice Department to place the case before a grand jury. Carl Belcher, a man who at that time was the head of the General Crimes section of the Criminal Division in Justice, absolutely refused to sign off on a grand jury investigation, and it died there. But we appeared before Judge Butler. Judge Butler swore in the Casabs in my presence, swore in Pete Casab, who was there with us. They all swore to what they said in the criminal complaint and the affidavit. The judge asked a lot of questions, took a lot of notes. A lot of the notes I've had the opportunity in recent years to read because he kept all of his own materials, Judge Butler, and he donated them upon his death to the University of North Carolina library. And so I got copies of all of them, and I was surprised at the detailed notes he was taking about the oral argument that I made and how Tom McNamara said to him, "Judge, my hands are tied."
I'm going to ask you a question.
Yeah.
But in spite of everything that Butler did decide, and I think he was impressed by the Kasabs and everything you had presented, the Justice Department would have the last word, whether or not to proceed with the prosecution.
That's right. And so Judge Butler, the day after we appeared in his chambers, which was April 30th of 1974, wrote a letter to William Saxby, the Attorney General, and said, "I've had this visit from Mr. Cahn and his clients, and they have presented a criminal complaint to me. Please advise me whether, if I convene a grand jury, you will present evidence to the grand jury. If the grand jury indicts, will you prosecute? Because the law, as you may know, there's some law behind this too. It's a very rare thing that a civilian files a complaint successfully. It turns out that there are only a couple of cases, one a Supreme Court case, in which the courts have held that the absolute discretion whether to prosecute lies with the executive branch of the federal government. However, the grand jury has what is called an inquisitorial function. It has the duty of investigating the facts. And the Supreme Court said that in investigating the facts, the grand jury can take its information anywhere it can find it. So you have this tension. You have a grand jury which could become easily a runaway grand jury and indict anybody without any real cause, and then the prosecutors decide they don't want to prosecute that indictment. So what's the point of it? So what I said to the judge is, look, Judge, I know it's a great temptation not to do anything here, because if you convene a grand jury and the grand jury wants to indict, the government isn't going to prosecute, perhaps. So, but I think the case is important enough. It happened. It's a sensational case. It happened on a government reservation. The government can't just close the file and not explain to the public why it has done that. So, make a long story short, the Tom McNamara, after our visit with him and with the judge, went to Washington, made a further plea to Carl Belcher in the General Crimes Division. Belcher still would not move, but Henry Peterson, the AAG in charge of the Criminal Division, overruled him. A grand jury was convened, and the rest is history.
Okay, this brings us to the trial, and I think that Richard and I had an interesting discussion yesterday relating to two things I'd like to ask you about. In none of your recapping of what had happened do we get into why Jeffrey MacDonald, let me just use this one, would have wanted to have killed his wife and two kids. What motive did he have? And I think we all know the prosecutor doesn't have to prove motive. It's not an element of the crime. But certainly the jurors sitting there at the trial would want to know, to understand it more, why would he have gone ahead and killed his two children and his pregnant wife in the violent way that had occurred. And I think if you just want to speak on the possible motive a bit, but even you felt uncomfortable in guessing what his motive could have been.
That's right. I don't know. That's the most troublesome part of the case. He had a number of extramarital affairs, the most recent one before the crimes being a couple of months. He and his wife did not get along. I learned that from the Kasab family. He was a very arrogant individual, very proud, a kind of Superman type of guy that you couldn't challenge without being shot down.
Yeah, and that's the other
and so there was not a good relationship there. It doesn't explain why all this happened. That's true. And I can't tell you. All I can tell you, and of course, what happened after we got finished on April 30th, 1974 is, that happened. That was not something that I have any personal knowledge of. But all I can tell you is that my strong feelings at the time that the physical evidence did not bear out any of what MacDonald said. And if he lied about what he did that night, he could have been confused, but there were just too many blatant inconsistencies. He even admitted at the trial that he lied to his father-in-law, said that he had gone down to a bar in Fayetteville and encountered someone that he felt might have been one of the perpetrators, and he took him outside and questioned him, and when he became convinced that the guy did it, he killed him. Well, there was no such murder that occurred in Fayetteville or in the surrounding area, anything like that, at anything like that time. And he admitted that that was a monstrous lie, and he did that just to get his father-in-law off his back.
I think part of your explanation for why there was a conviction was because Jeffrey MacDonald made the decision that he wanted to testify at trial, and he was someone who didn't come across well. I mean, he was arrogant and...
Yes. I saw him. I went down for the day of cross-examination, and I was quite unimpressed with his credibility. He didn't do himself any favors. He didn't have to testify at the Article 32. He didn't have to testify at the grand jury, and he didn't have to testify at the trial, but he testified in all three places, and he just dug himself a deep hole.
So I just wanted to add one thing about motive, and that is my interest in this came from, there's an extraordinary set of books that have been written about the case. The first one is a very famous nonfiction novel, basically. It's by an author named Joe McGinnis, who was with MacDonald and the defense team as the case was going on. So he had extraordinary access to the defense team. And McGinnis concludes, as does Richard and as did the jury, that in fact Dr. MacDonald was guilty. And then there have been books written about that book, saying that about the relationship between the journalist, right, McGinnis, and Dr. MacDonald. To circle back, though, to the sort of first level, Mcginnises Theory, disclosed at the end of a very long book, is that in fact MacDonald, as part of his Green Beret training, was taking diet pills, something called esketrol, and he was taking them in high doses, and that during the preceding weeks, the months sort of leading up to the murders, he was working very hard, he was taking too many diet pills, and this made someone who had the personality, right, Richard Cahn's description of Dr. MacDonald is consistent with what Joe McGinnis says, the arrogance, and so on, and that what seemed to have happened that night was some sort of domestic incident or fight that spiraled out of control very quickly, and that's what led to the murders. So I'll stop there, but that's what I think helps. There are it is, and that theory is contested. That is, as to motive and the diet pills. Would diet pills do this or not? I should also add that with respect to the diet pills, that wasn't presented by the government to the jury, to my knowledge. Does that accord with your recollection? But that is something that is in one of the books about the case.
Could you also just, if you feel free, to talk about your reaction to the defense lawyer, Bernie Siegel, who represented Jeffrey MacDonald at the trial? Because I think when one looks at why there was a conviction in spite of the shocking nature of the crime and the lack of motive for the defendant, I think one looks at the defendants testifying, and the jurors didn't like him, and he came across in this arrogant kind of a way, and it's never good to have the defendant disliked by the jurors. But then also you had some things to say about the defense counsel in the case.
Well, from everything I have heard and from my brief opportunity to observe him in action, he is a very flamboyant, self-promoting type of guy, not the type of guy that probably would go down well in with a group of jurors from North Carolina. It's shall I say, a little bit more sedate group of people who like to see respect and dignity, and Siegel, with his hair flying all over the place and his unkempt suits and his loud, brassy manner, really wasn't a good fit. As it happens, he was smart enough, Siegel, to engage Wade Smith, who at that time was an older, very dignified, extremely well-respected lawyer in North Carolina as co-counsel in the case. But unfortunately, Siegel was unable to let go of the spotlight, and Wade Smith did very, very, very little. One other postscript about Siegel is that when Judge Fox, the federal district judge in North Carolina, in September, was presiding at this hearing, Joe McGinnis, the author of the book that Rodger Citron mentioned, Joe McGinnis was called to testify, and as Rodger said, he was embedded with the defense team, and so he was present in the courtroom, present at the private conferences, and he flatly testified that Bernie Siegel lied to Judge Dupree during the trial. The argument was about whether Helena Stokely, a woman who resembled this woman with the floppy hat, one of the four hippies, was arrested as a material witness, brought to testify at the trial, and when she testified, she denied any knowledge at all of participation in the crime, any complicity herself, doesn't have any recollection of ever being in the MacDonald house. And so the judge refused to allow Siegel to present 6 or 7 of her acquaintances who he was going to put on the witness stand, and they were going to testify that Helena Stokely told them that she was present at the time of the murders and she saw them committed, and she was horrified. And Judge Dupree ruled out that testimony as not reliable.
And that's certainly been one of the issues on appeal, the judge's refusal to have permitted those witnesses who would say that this woman told them that she was there.
That's right. And it's one of the issues on the 2255 hearing before Judge Fox, too. But I thought it was quite an indictment of Siegel that McGinnis, who I don't think is an untruthful man, felt free to say that he lied to the judge about what Helena Stokely said. Wade Smith is still alive. He was called to testify, and he testified last September that Helena Stokely did meet with the defense, but that she gave no evidence, no information of value to the defense case. So you've got forget what you think or don't think about Joe McGinnis, who wrote this book and got criticized for it. Here's Wade Smith, who's an impeccable, distinguished lawyer and has had a distinguished career in North Carolina. He came and testified also that what Siegel told Judge Dupree was not true.
And to put the Stokely testimony and how the trial court judge handled it, it's actually a fascinating evidentiary question or issue. We talk all the time in civil procedure and evidence and other courses about the discretion of the trial court. To give the defense's side of the Stokely story, if you go back to Dr. MacDonald's story, right? He said 4 intruders, 1 woman with who I think was described as having blondish hair. And it turns out that Stokely at different points, Helena Stokely said that she was out with 3 people that night. She owned a blonde wig. And then she began having memories of being in the house. Now, it turns out that after she was arrested, each side had the opportunity to interview her before she testified at the trial. And consider the time lapse, right? The event was in 1970. The murders were in 1970. The trial was in 1979. Stokely's testimony was presented to the jury, and she consistently said, she admitted being a drug user, a heavy drug user at the time, but my recollection is that she consistently said that she had no memory or no knowledge of ever being inside the house, denied being involved in the crime. Now, what's interesting was, it was sort of a two-part strategy by the defense, right? First, we call Stokely to help plant reasonable doubt, because she's going to talk about, I was there with a candle. That's all I can remember, but I was there saying things like acid is groovy. And then, on top of that, the defense planned to bring in these 6 or 7 witnesses. I think it was 6, and then it actually became 7 during the course of the trial, who would corroborate, right? And this was thought to be very significant, a very significant prospect or opportunity for the defense to create reasonable doubt, right? Because there's only 2 competing narratives. Either MacDonald did it himself, or the 4 intruders did it. What Stokely did not, right, part 1 did not work out, but the defense was hoping, well, we'll still be able to raise a reasonable doubt through the corroborating witnesses. But the trial court judge, for a number of reasons, he heard the testimony outside the presence of the jury, of the 6 people who had heard these statements by Stokely about, I think I was there, I have a memory of being there, and so on. It was he had a basis for doing so under the rules of evidence. He had a basis for doing so, actually 2 different rules of evidence, right? The hearsay rules, as well as the Rule 403, the basic rule about probative value versus prejudicial effect. And then there was simply a discretionary decision by the trial court judge. And he decided Stokely's testimony in and of itself is inherently unreliable. He did not allow the 6 other witnesses to testify in front of the jury about what they had heard. And this became an important issue on appeal, and at least one judge on the Court of Appeals was troubled by the decision. Not enough to say the conviction should be set aside, but enough to say, in a case like this, the benefit of the doubt should have been let the jury hear it all and let the jury decide it all. And that is, in fact, still one of the open issues now in this last evidentiary hearing, in this last appeal before the district court, which the hearing was in September, and we're still waiting for the decision. That is, all the parties as well as the public is waiting for the decision. But it's it was an important part of the defense. Over time, it seems to have become even more so. That is, this idea of if Stokely was telling the truth, that would create a reasonable doubt.
There was a book which came out last year which prompted both of these people to write responses to the book, a book by Errol Morris, whose name we've mentioned a couple of times in criminal law, advanced criminal law. He's someone who, as a filmmaker and also an author, and he wrote a book called A Wilderness of Error, The Trials of Jeffrey MacDonald, raising very serious concerns that he had, and a painstaking book going through an awful lot of the evidence. And he reaches the conclusion, you concluded he reached the conclusion, he didn't actually say as much, but that Jeffrey MacDonald is innocent of the murders. That led to Richard Cahn then writing a review of that book, an Our Law review, which basically takes Errol Morris, you chastise him and reach your own conclusion, which you've reached in the past, which is that Jeffrey MacDonald did, in fact, in spite of everything Errol Morris wrote in this book, kill his wife and children. And then Rodger Citron also wrote a review of that Errol Morris book, where Rodger ends up concluding that yes, there are some questions that do raise some kinds of concerns about how fair the trial was, but nevertheless, Jeffrey MacDonald did kill his wife and children.
Did in italics.
Yes, right. No, he put the did. At the very end, Jeffrey MacDonald did kill his wife and children. But could you talk a bit just about how fair the trial was in your eyes, to what extent the publicity that was accompanying the trial was a problem. Were you there for the voir dire at all?
No.
Okay.
No.
But just talk a bit about the media coverage of this trial while the trial was going on.
Yeah, there was enormous media coverage, day-by-day coverage. It was on the AP, it was Ticker, it was national news, and it got a great deal of attention. Probably that's an inevitable problem that we have in this democracy where the press is free to write anything that they want to write. It does raise serious questions. I think, all in all, Judge Dupree ran a fair trial. I think that some of the things that he did were legitimately subject to being questioned by the defense on appeal. Among them, the exclusion of these witnesses under Federal Rule of Evidence 804 that would have rehabilitated Stokely into a witness to the murder. But one of my conclusions in the law review article is that there is a problem with continually, again and again and again, raising the same issues. I think that there is an enormous burden. There's a very large statutory burden under Section 2255. You have to virtually prove actual innocence in order to get a rehearing. So I think the Fourth Circuit did the wrong thing in ordering this 2255 hearing in the first place. I point out in the article that so many of these issues, in fact, I think all of them, have been contested, ruled on by the trial judge, Judge Dupree, ruled on by the Fourth Circuit, and on a couple of occasions ruled on by the Supreme Court. And as much as I have libertarian instincts and want defendants to have a fair trial, enough is enough. I think there is a point where you don't want to keep retrying a case again and again. Now, I don't think it's any accident that this hearing came up after Freddie and Mildred Kassab both died. Moreover, almost all of the witnesses, including Helena Stokely, are dead. All the witnesses that Morris talks about in his book that would buttress MacDonald's story of the murders. There's a federal marshal who 2 years ago made an affidavit saying that he escorted Helena Stokely from Pickens, South Carolina, to the courthouse in Raleigh when she was under arrest as a material witness, and during that long drive, she confessed the crimes to him. But the records, as well as the live testimony last September on the part of all the people in the marshal's office, was that Jimmy Britt, the marshal, could not have been telling the truth, and he knowingly lied, because it's very clear that he didn't set foot in South Carolina. He only picked up Helena Stokely at the jail in Raleigh and drove her 10 minutes in the presence of a matron to the courthouse. He wasn't with her for 6 hours. He was with her for 10 minutes. Britt is dead. There are investigators who took upon themselves the task of rehabilitating Jeffrey MacDonald's innocence and have supposedly uncovered other witnesses. Those witnesses are all dead. How long do you keep it up? I suppose you keep it up theoretically until Jeffrey MacDonald is either released or he himself has died. But it's a very troublesome thing to me. And despite what I said about the First Amendment, I was troubled by Morris's book for two reasons. One reason is that he told me when he interviewed me for the book that he had just started working on it, and that he hadn't really made up his mind whether Jeffrey MacDonald was guilty or innocent. Well, in fact, if you read the book, you see that he started working on it 10 years ago, and it's very clear from what he says in the book that he does believe, and he reached the conclusion a long time ago, that Jeffrey MacDonald is innocent. Second of all, I really believe that the publication of his book was timed to coincide with this hearing and to influence the public, and through the public, the judge, in hearing this testimony. Now, this in ruling in MacDonald's favor on the basis of triple hearsay testimony and whatever else he's got there, MacDonald may prevail. The judge may feel, as Rodger has said to me on occasions, that there are some things that are troublesome in the case, and maybe Judge Fox will feel that those troublesome things are sufficient to order a new trial. Well, if you order a new trial now, after how many years? Almost 40 years? With all the witnesses and more than those that I've talked about, all dead, it's pretty clear, it's self-evident that no new trial could ever result in a conviction, and if the judge grants the writ and releases him, he's out for good. That's the end of any prison term for Jeffrey MacDonald. And I just have a problem with writing a book that is, in my view, consciously intended to influence the course of justice.
He spent 10 years on the book. It wasn't that, there's going to be a hearing, or let me write a book quickly, which is now going to lead to the Fourth Circuit determining there should be a hearing. He spent an awful lot of time painstakingly going through it all. It wasn't just from the tip of the cuff. But let me just add one thing, and then Rodger will give the concluding remarks.
Go ahead.
Sometimes it takes an awful lot of years before a conviction is shown to have been an improper conviction. Any number of examples. So the fact that so many years have gone by, that doesn't mean in and of itself that we have to leave it. We have to accept the fact that enough is enough. Because sometimes it takes many, many years before finally people become aware that the conviction was simply a wrongful conviction. But Rodger.
So a couple things to sort of close. The first is, this is as I was reading the Joe McGinnis book last night, as to jury selection, this was very interesting. MacDonald's defense team hired a jury expert. This is in the book. Hired a jury expert and ran the case and said, "Who's the ideal juror here?" Interestingly, and even MacDonald is described in the book as sort of not believing it. The ideal juror, according to their expert, was someone who would be, so to speak, conservative, white, middle-aged or older, very establishment. And the thought was, at least according to the jury research that was done for the defense team, was what the consultant was saying was, you need someone in the jury box who will empathize with you and say, that could have been me wrongly placed in the jury box. And so that's what that decision-making process is what guided, or those thoughts guided the defense team in the decision-making process. Interestingly, an ex-Green Beret, I beg your pardon, the SEALs are today's Green Berets, an ex-Green Beret was on the jury and is described as actually weeping when the verdict came in, which was guilty, right? Guilty on all three counts. Second thing is, as to Errol Morris, this is my own private view. That is to say, it's a completely speculative guess. I think that Morris, in writing the book, sometimes you see him on the New York Times, online, on the opinion page, right? He wrote a book, Believing is Seeing, that looks at sort of, well, maybe it isn't that we see data and then process it. Rather, our minds condition us to see what we want to see. And I think that Morris has what I call the Hannah Arendt problem, which is to say, he's got a great theory, but he picked the wrong case. Because the facts here, at least in my view, ultimately, I think do show that MacDonald did, italics,
commit the murders. Third thing is, for any of you who are interested in reading more about this, and be careful because you can sort of go down the rabbit hole with this case and become obsessed with it. But I sent Professor Klein an email before the panel a week or so ago, or 2 weeks ago. Links, it's an email with links to 4 different articles. One is my review, one is Richard Cahn's review. There's a marvelous Washington Post magazine article about Errol Morris and the book, and I think there might be one other article or so on it. But if you are interested in it, it is very engrossing, and I could send you those links, or Professor Klein could, from the email that I did. I think our time is up, so I'm going to give it to Professor.
Yeah, so what we've attempted to do in just a 50-minute period is give you some kind of perspective of this trial, which again is one which an awful lot of people have spent a great deal of time analyzing. Whether it's possible to do justice in any way in such a short period of time to what had happened, I'm not sure, but I do hope that it's been educational and we've raised some basic kinds of concerns and issues. So I just want to thank Richard Cahn and Rodger and the Law Review for putting this together. Thanks.